A very good evening to one and all present here, respected seniors and my dear colleagues. Today, I feel very enlightened and I feel very ecstatic to have got this opportunity to introduce our 7th edition of study circle conducted by the BharatheeyaAbhibhashakaParishad. First and foremost, I would like to thank our organizers for organizing this event, without whom this event would not have been possible. That being said about it, now it's time for me to welcome the speaker, who happens to be Mr. Vinod Bhatt sir, who is not just an accomplished lawyer, but at the very same time is a multifaceted talent, who would be enlightening us with the topic of Kerala Building, Lease, Rent and Rent Control Act. So without further ado, I would like to welcome sir onto the stage. So I think without further ado, we can start our session. So yeah.
Good evening, friends. The topic for the day is question and answers on Rent Control Act. So necessarily, I expect a lot of questions from you. But before questions come from your side, I'm pretty sure that most of you know about Rent Control Act, but that any person here who is not very adept with the Rent Control Act, I just thought I'll just lay a foundation for them so that questions can come from there and too. So, Rent Control Act, the Kerala Building Lease and Rent Control Act 1965 was enacted. Interestingly, it came into force on a very eventful day, that is, it actually is a piece of legislation which, seen about 60 years down the line, has been rather, I should say, fooling the tenants for the simple reason that the purpose of the legislation was to protect the rights of the tenant. But as on date, as we see, this is an act just to evict the tenants, not to save the tenants, which was the intention of the act. So the act, interestingly, came into force from the 1st of April. That is why I said it is rather fooling the tenants, and so it defeats the very purpose of its legislation. But then that matter apart, but then who are the parties to a petition under the Rent Control Act, and what is the purpose of the act? For the beginners, so I'll just conclude all these things in about 5 or 10 minutes. Rent Control Act necessarily deals with two parties, the landlord and the tenant. Now, who is the landlord and who is the tenant? For the beginners, I would just say, as you just walked into this hall, you must have seen Dhanlakshmi Bank and other shops on the ground floor. Now, how is it that Dhanlakshmi Bank is functioning in this building, which is more occupied by, the lawyers here? You have about 400 to 500 lawyers in this building, but you find Dhanlakshmi Bank here. How is Dhanlakshmi Bank here? Dhanlakshmi Bank is a tenant. That is, it's on lease from the landlord. I think the landlord is the association, that's the Kerala High Court Advocates Association. So they are in occupation of that part of the building. When I use the word occupation, I should be careful, because once a party is said to be a lessee, that is, the Lakshmi Bank is a lessee, it is parting with possession of the property. So when I use the word occupation, it's a loose description of a lessee. So Dhanlakshmi Bank is a lessee, and they have a right to be in possession of that particular property as a tenant, and the landlord being the Kerala High Court Advocates Association. So two parties here. On one side you have the landlord, and on the other side you have the tenant. Now, the duty of the tenant, you know very well. You pay the rent and you act according to the terms set out by the landlord. And as far as the landlord is concerned, he is to maintain that premises fit for possession of the tenant. Broadly, this is what the landlord and tenant relationship is. But then, because of this special statute, that is the the Building Rent Control Act, came into force for two purposes. One, to fix rent. The second purpose was as to how you would evict the tenant. Now, why this special legislation was brought into force? Was not there a legislation before the BRC Act? I would just use in short BRC Act, that's the Building Rent Control Act. Before coming into force of the BRC Act, the relationship between a landlord and tenant was governed by the General Act, that is the Transfer of Property Act. Now, under the Transfer of Property Act, essentially the tenants did not have any say in the matter, because it was a contractual relationship between the landlord and the tenant. And so you had to act as per the contract, and whenever it was the sweet will and pleasure of the landlord to evict the tenant by giving a statutory notice. So all that was required is issuance of a statutory notice by the landlord, and you could easily evict a tenant. Now, eviction of tenant became quite easy under the Transfer of Property Act. But then, because of the change in circumstances, why it led to 1965 enactment was basically the two World War, that's World War I and World War II. And to save indiscriminate eviction of tenants, the legislature then thought that some safeguards have to be laid for protecting the interest of the tenant. And that is how the 1965 Act came into force, to protect the interest of the tenant, more to protect the interest of the tenant. But I would not say that landlord's rights are completely struck down or they don't have any more right. They do have right under the Rent Control Act, but the balance tilted in favor of the tenant. The balance was overwhelmingly in favor of the tenant. The tenants were well protected if you go by the real intent of the 1965 Act. Now, under the 1965 Act, as I said, largely it has few provisions, namely provision 5 to 10 or 9 maybe. I'm sorry, it must be 5 to 9. And then from 11 onwards, it is regarding the section 11 and 12 deals with eviction. 12 essentially does not deal with eviction, but still then I come to section 12 for the purpose of section 12. So section 11 is how you can get a tenant evicted. Now, as far as rent is concerned, fixation of rent is concerned, because of a ruling in 1995, that's Isaac Nine case, it becomes quite easy for me to say that most of the provisions relating to fixation of rent have been struck down. So there is nothing much for us because it's as good as it's not there in the Act at all. Those provisions are not there in the Act at all. But then Isaac Nine was again taken back. I'm sorry when I say taken back, in a way the High Court itself rewrote Isaac Nine saying that not all provisions get struck down, but then one provision was same, that was section 5(1), that the rent control or the civil code could now fix the rent. So as far as power of the court to fix rent, that still remains, but all other provisions under section 5, 6 and 8, they have all gone, so you don't have to go through 5, 6 and 8 barring section 5(1). Now, this is as far as the rent is concerned, that you can go to the rent control code or even to the civil code as the case may be for fixation of rent. Now, as far as eviction is concerned, you come under a landlord can evict a tenant only if he satisfies the conditions under section 11. Now, section 11, if you have a book with you or when you go back home, kindly see how it starts. That is very important. It says, notwithstanding any agreement between the parties, a judgment, decree or whatever it is, you can evict a tenant only if you satisfy the grounds that are set out in section 11. So even if you have a contract to the contrary, that doesn't save you. It is only a ground which is enumerated under section 11. If the landlord satisfies one of the grounds under section 11, then alone a tenant can be evicted. Now this is how the safeguard has been created by the legislature by bringing in section 11 as a provision to see that there is no indiscriminate eviction of tenant from the premises. Now, as far as lawyers here who practice in the High Court, they are faced with basically three types of memorandums. I should say one, a rent control revision, which we give the name as RCR. The second is OPRC, and the third would be an OP Civil under 227. Both under 227, there's OPRC and OPC. Now, RCR is basically power that you get to file a revision before this court through section 20 of the Act. That is from an appellate order by appellate judgment that is passed by the district court. You file a revision before the High Court, that is nomenclature as RCR. The second, that is OPRC, is basically from an interim order that has been passed by the Rent Control Authority. And Rent Control Authority could be, when you are filing an OPRC, could be an interim order that is passed by the Rent Control Court or an appeal therefrom, which is an order passed under section 18. So when an appellate court is deciding an issue or when an appeal is pending before the district court, there could be an interlocutory application, and from an order in that interlocutory application, you may file a OPRC before the High Court. Now, OPC, that is generally less seen from a proceeding which arises from the Rent Control Court or from the Rent Control Appellate Authority. But then OP Civil is generally filed when the proceedings the original proceedings under the Rent Control Act are completed, and then a petition is filed for execution of an order. Now, there lies a slight difference, and execution is not done by the rent control code. It is simple as to why there is no such power. The statute itself says that execution should be by the principal munsif. Why principal munsif? That is because rent control court is, once upon a time it was said to be a tribunal, but now the trend changed and the courts have said that it is only a court but not a civil court. At any rate, not a civil court. So bear in mind that a rent control court is a tribunal at one point of time, was a tribunal at one point of time according to then understanding. It changed and the power now is as a court but not a civil court. So therefore, execution of an order that has been passed by the rent control court, that is an eviction order, has to be executed before by filing an execution petition before the munsif. There is no power for the rent control court to execute its own order. So that is where it falls short of a civil court. Now, any order that has been passed by the execution court while executing, there could be interlocutory applications which you file even on the execution side at the time when the landlord is trying to execute the order. Any interlocutory order that arises from the execution side, if you want to challenge it before the High Court under 227, there you don't have to give it the tag OPRC because rent control proceedings are already over, and now what you are doing is actually an execution, and that execution which you do is basically following the civil procedure code, and therefore the nomenclature that is given to such OP which is filed under Article 227, they are nomenclatured as OP civil. So as a High Court practitioner, you will be faced with three types of memorandums, that is RCR, OPRC and OPC. Now coming to another provision, that is section 12. Here too, what we see is when a tenant is not paying rent, the landlord, it could be the sole source of income for it or even otherwise, he can file an application under section 12. But bear in mind, section 12 application is not a standalone provision. Section 12 application can be filed only when you have a section 11 petition which is pending. So understand that section 12 application cannot be filed as a standalone, like you cannot file a section 12 petition without a section 11 already pending in the rent control code. So unless you have a section 11 petition which seeks for eviction on any of the grounds under section 11, there is no scope for a section 12 petition. A question may probably run in the mind of any beginner as to if there is an application for fixation of rent, can a section 12 petition be filed? The answer is in the negative, it cannot be filed. So an application under section 12 is contemplated only when you have a section 11 petition pending before the court. Now, what is the scope of section 12? Section 12 is an application filed by the landlord under section 12. What the court does when it is faced with a section 12 petition is, it asks the tenant as to why you are not depositing the admitted rent. Mind you, my friends, it is only when it comes to an admitted rent that section 12 can be brought into play. If there is no admitted rent, there is no question of landlord filing a petition under section 12, or the court cannot be determining a petition under section 12. So unless the court is sure that there is an admitted rent, there is no question of application of section 12. So the two ingredients now which I have just stated: one, there should be a section 11 petition in place for you to file a section 12 application. Second is that there must be an admitted rent. Without an admitted rent, there is no question of filing a section 12 petition. Now once an application under section 12 comes, the court then asks the tenant as to why he is not paying the admitted rent. Now the court necessarily has to give time to the tenant as to why he is not paying the admitted rent. For this purpose, the Act itself says that once an application under Section 12 comes in, the court gives time to the tenant of 4 weeks, of not less than 4 weeks, as to why he is not depositing the admitted rent. So necessarily what the learned Munsif would do is to post the case any time beyond 4 weeks, so as to enable the tenant to come forward with a reason as to why he is not paying the admitted rent. So once the time given by the Munsif court, has run out, the tenant is stricto sensu who has not given a cogent reason for why he has not deposited the rent could face the consequence under 12.3, that is termination of proceedings and a direction by the court to hand over possession to the landlord. But here too, because of judicial intervention and because of the play of natural justice, the courts have said that even after the period of 4 weeks, the court is to give a further time to the tenant, requiring him to show cause, and then if he still does not show a genuine cause for not depositing the admitted rent, then he faces the consequences under Section 12.3. 12.3 says in simple language that the court then stops the proceedings and then directs the tenant to put the landlord in possession of the premises. So this is the scope of Section 12. Now, other provisions which you may be interested in is Section 18, that is any person who is practicing in the district court or maybe in the municipal court, that is once there is an order by the rent controller, then an appeal lies under Section 18 from any order that has been passed by the rent control authority. That comes necessarily before the district judge, and once the district judge adjudicates on it, then there is a scope for revision which is under Section 20. Now, with this foundation, I think I can just invite questions from your end. In case you require further any elucidation on any of the specific sections, you are free to ask, or you can just ask questions on other fronts also.
Section 14. 14. Section 14.
14 is
Exhibition.
execution. Yeah. That's, Madam just wants to know something about execution. As I just said, execution is not by an order which has been passed by the rent control authority, which has become final, is not executable by the rent control, because general law, as we see in the Code of Civil Procedure, is that the court of the first instance has the obligation or has the right to execute its judgment. But here it is different, because it is not, the rent control court is not taken as a civil court. It does not have the right to execute its own order. So there is a statutory bar itself, because the statute section 14 itself very clearly says that the execution petition is to be filed in the munsif's court, and that to the principal munsif itself. So therefore, a execution petition is placed always before the principal munsif and not before the rent control court. Now, why?
Limitation.
Of?
Limitation filing execution.
But it's again normal. It's just because once there is an order, if you want to get it executed, it is again the 12-year period. Basically, what are you doing? It's a recovery of possession order. Section 11 is to recover possession from the tenant. Now here we say, in loosely we say we are trying to evict the tenant. Eviction of tenant is necessarily or it's equal to recovery of possession. So if you had the TP Act in force, you would be now saying that I have to get back possession. That is why I said at the beginning that though I have used the terminology occupation, which is related to a licensee, here it is a possession that the landlord parts to the tenant. So when Possession is parted by the landlord to the tenant. Now landlord has to get back possession. Now how does he get back possession? You have to ask for recovery of possession under the Transfer of Property Act. So section 11, when you say that you are going to evict a tenant, necessarily means you are going to get back possession from the tenant. So it is again a recovery of possession necessarily, but then loosely we say we have to evict the tenant and give possession to the landlord under any one of the grounds under section 11. Because it's a question and answer, I thought I should be, not speaking too much and laying a very big foundation. I just thought if questions come from your end, it becomes easier.
Sir, under section 11(9), it is said that unless and until the contractual period expires, one cannot file a eviction petition under 11(9). And there are provisions 11(2), 11(3), 11(4), 11(7), 8. We can those sections categorize the eviction grounds. So, can we file an application under section 11(2), 11(3), even within
the period? That's a very good question. Now, section 11(9), it bars filing of a petition if there is already a contractual period set between the landlord and the tenant. I think that's the purpose of section 11. So a question may arise. Now suppose there is an agreement between the landlord and the tenant that a tenant would be in possession for a period of 5 years. And they have in fact executed a lease deed for 5 years, which is registered. Now, within the period of 5 years, can the landlord evict the tenant? If you go by a mere reading of section 11(9), it would be a clear bar in filing a petition for eviction of the tenant. But can anybody agree with section 11 as we see it in its literal sense? What do you feel? That if you have a 5-year period of tenancy, then until that 5-year period is over, the landlord cannot approach the rent control code for eviction under any of the grounds under section 11. Can that be the manner in which you see section 11? Section 11(9), I'm sorry.
What happened 11(2)?
No, I'm just asking generally as to can you actually see the provision in that manner? Do you feel that it would be an injustice for the landlord?
So there will be a clause in the rent deed that before evicting or before we are vacating, 3 months notice should be given.
Madam, this is where again section 11 parent proviso says that notwithstanding any agreement between. So when you say that there is a clause in the agreement, ignore the agreement is what it says. You can seek for eviction only if the landlord satisfies the ground under section 11. But then my question again, if seen strictly in the sense of section 11(9), could be defeating a landlord completely, because he will have to wait for a period of 5 years till a petition under section 11 is filed. Imagine a situation where, as Advocate Manmohan said, 11(2)(b). 11(2)(b) is somewhere, it is filed when somebody is in arrears of rent. That is, somebody in the sense where a tenant is in arrears of rent. Imagine a landlord and tenant entering into an agreement today on October 25th or 24th, I'm sorry. And then it's a 5-year term. Right from the beginning, the tenant fails to pay the rent. Can this embargo or restriction that is brought in by section 11(9), if read in its literal sense, what it means is the landlord has to wait for 5 years without any rent to evict a tenant. Is that the manner in which any court would see section 11(9)? Now I think you will be able to give a better answer. Still silent. The answer, I know it's there in your mind. It cannot be, because it would be gross injustice that is caused to the landlord. So that is where the Supreme Court itself Kindly don't ask me citation because I'm very poor on that side. But now that you have the Google Guru with you, kindly search for this judgment by the Supreme Court. How the Supreme Court saw this? It's by Justice Ravindran, that I know, R.V. Ravindran. How the Supreme Court saw this situation was, it arose from Karnataka High Court. It said that when a tenant, I'm just telling the principle so that it becomes easier for you to understand. When the tenant has breached his obligation, what is his obligation? His obligation is to pay the rent. Now, his obligation, when he breaches, then kindly don't, because that obligation actually springs from that agreement between the landlord and the tenant. Because the landlord and tenant have agreed that landlord will give possession of that building for 5 years to the tenant, and the tenant has agreed that he would be paying rent on a monthly basis to the landlord. So this is the obligation. Now, when the tenant has failed to oblige his duty, that is the obligation that is cast on him, that is to pay the rent, can you then say that the obligation on the landlord to still see that the tenant is there for 5 years honored, despite the tenant not honoring his obligation? So both of them have to honor their obligation. Tenant is to pay rent. If you have breached it, if the tenant has breached that obligation, then the tenant cannot take a cover under the rent agreement which gives him the protection for 5-year term. So if you want the protection that is given to you of a 5-year period under the agreement, kindly honor the agreement in its totality. If you commit a breach of that agreement, then you cannot then hide behind that agreement itself which you are breaching. So this is the manner in which the Supreme Court saw and defeated that argument, saying that the landlord has to wait for the agreed period. That is, if there is a period that is agreed between the landlord and tenant, he cannot prefer an application under Section 11 within the period agreed. So you can still come before the court if there is a breach. That breach should be fundamental breach of the agreement by the tenant, and that should be alleged as the ground for removing the shield that was given to the tenant.
The tenant is not paying the rent for ab initio.
Ab initio means from the very beginning.
From the very beginning. If he pays 1, 2, or 3 installments and qualifies as a tenant, then how it happens? What is the...
Well, tenant anyway gets a protection because irrespective of whether he pays the rent or not, under our law, he is nevertheless a tenant. He continues to be a tenant. Non-payment of rent doesn't make him not a tenant. But then your question is, he pays for 3 months.
3-4 months he has paid.
And then he defaults.
Yes.
It is the same. See, as long as he pays, there is no breach of agreement. But when he commits the breach, then he cannot take the cover under the agreement to say that landlord cannot evict me because there is a 5-year term.
But it is quite natural that there are certain defaulted installments, 1 or 2 installments. It is defaulted. Then how it can be faced by the landlord?
Are you asking the question in the backdrop of Section 11(9)?
It is natural that a rent agreement, the tenant makes default at certain times.
Yes. He makes a default at a certain time.
Then he becomes fully disqualified for being a tenant. And the landlord can take action.
For what? Landlord can take action for what?
For default.
That is, you are not under 11(9). The question is not under 11(9). Or is it a question under 11(2)(b)? Is the question under 11(2)(b) for default of rent?
Default of rent.
Now, if there is a default of rent, the provision is 11(2)(b).
11(2)(b).
Now, if there is default by the tenant, then the landlord can approach the rent control court for alleging that there is default of rent. I thought the question was linked to 11.9. But then if the question is not connected to 11.9, then the answer is if there is a default of rent, then the provision that is applicable is 11.2b.
Just that one tenant is evicted on level 2B, the grounds of level 2B. But there is two There is no mechanism provided in the Tenant Control Act for getting that money. You have to file a money suit, isn't it? So wouldn't that be saying that
Will that not be?
wouldn't that be a wrong on the landlord, saying that the act has been fooling the tenants?
See, basically, this Rent Control Act is not for actually realization of money. That's why I said at the beginning that the intent of the act is only for two purposes. One for fixation of rent and the other for eviction of tenant. So your question is basically for realization of money, that is realization of rent which was defaulted. So that this act, it is outside the scope of this act, for which necessarily you will have to fall back on the general law, that is you going and filing a regular civil suit.
Cases, landlords are taking license agreement instead of lease agreement. In such cases, what would be the remedy for the tenant?
For the tenant or landlord.
Licensing. License. Is the license
Remedy for tenant, remedy for the tenant. When a landlord, when the landlord gives the caption that it's a license deed.
license agreement?
Exactly, yeah.
There will be a timing is there. You can enter the premises by 7 a.m. He has to leave by 7 p.m. or maybe 8 a.m. to 8 p.m. accordingly. So in such circumstances, what will be the right of the license if in case of eviction is there?
Your question is very much interlinked to or something like linked very much to the two concepts. One, a licensee, and the other, a lessee. Basically, courts have found it very difficult to bring or draw a distinction between a licensee and a lessee. Now, if he is a licensee, then there is no question of application of this act at all. Because relationship under the Rent Control Act, as is obvious to you, is only when you have a landlord-tenant relationship. The dual relationship should be as a landlord and a tenant. So, lesser-lessee relationship is a bedrock of this act. Now, if instead of lessee, he is a licensee, then the Rent Control Act doesn't apply at all. So, the courts have to first find out whether he is a licensee or a lessee. Most of the deals where landlords want to hold a upper hand, they would execute a license deed to bring down the status of the lessee to that of a licensee. Because you know, under the civil law, the smallest of the right is there for a licensee, whereas right of a lessee is far larger than that of a licensee. So, if the landlord wants to get an upper hand, he would always show that the deed was a license deed and it was not a lease deed at all. But then it is quite easy to draw a distinction between a license deed and a lease deed. There is a whole lot of a difference between a licensee and a lessee. Now, how can you at any point of time say that, take the case which I started with Dhanlakshmi Bank. Tomorrow, if we, the association, or take it was a landlord individual, tomorrow just claims that the deed which was executed with Dhanlakshmi Bank is a license deed, can it be immediately accepted? Imagine the infrastructure that the bank has brought in. A licensee can never do that. Licensee, as you know, it comes under the Easement and License Act. is a permission that is given by the owner for a use, but for that permission, he is a trespasser. I hope you are understood. So when an owner just gives a permission, like, okay, now today you use this hall for the purpose of this particular seminar or this function. This is just a license agreement. The moment this seminar or this program is over, we have to walk out. Can we say that we are lessees here? Can't. So this is basic difference between a license and a lease. So when a mere right of user is given for we people to assemble here, have this program, and then a time is also set by whoever is the owner of this hall, that it is to be used till about 7 o'clock. I'm sure I'm going to wind up the session before 7. So it's going to be used till a particular point of time. It is only a license, it's a permission that is given to us. Now we cannot say that we are lessees here because presently we are in occupation. That is where fundamental difference between the term occupation and possession lies. Occupation is we are just occupying this room for few hours for this program. But possession is something larger. That is what you find presently with the Lakshmi Bank on the other side. They are in possession. They are in complete physical control of that premises which is given to them on lease. Now that there are too many beginners here, it will be really difficult for them to digest this. So I think as you being a full-fledged lawyer, you have understood it, but then I don't want to take extreme, something like make extreme propositions here. So basically, landlord will always try to tag a deed as license because for him, he gets an upper hand there. And he does not have to then come under the Rent Control Act. He can just go file a suit for, if it is a time-lagged one, then it's a recovery of possession, other for mandatory injunction. He just needs to file a suit for mandatory injunction to evict. Because there are certain restrictions that usually comes when there are certain types of leases which literally you cannot get an eviction. I think one comes under 11 when you give premises to a government body or to an educational institution or such other institution, then there is no question of literally the landlord cannot get back the premises.
But landlord can evict the landlord itself is a public entity.
That is correct. So, if it is a government organization, then where is the question of landlord also becoming a government? That are extreme cases, which may not arise at all. So, in such cases, landlords may take a case that it was a license that was given, but then pretty ridiculous would be for the fact that government will not act on license because they have their own lawyers, legal team to say that don't go for a license, go for a lease because they are well protected.
This law is operational only in certain notified areas. What about the other areas?
You will have to go under the general act.
Which is the general act
The transfer of
also
property act.
TPI.
Landlord acts on the building person.
Sir, I am not able to hear you.
Landlord give it to building a person. Later they enter into partnership.
Partnership.
And committing some and thereafter when some dispute arises between the parties. Now the other person is occupying the building. He is ready to pay the rent also.
The agreement was between two persons, A and B. In your case, I say A is the landlord and B is the tenant. Now, B, what he has done is, he has a partnership in which C and D are partners. So now immediately just see the equations, how they change. The first equation is A, landlord, and B, the tenant. C and D, who are they in that equation?
Partners.
They are partners vis-a-vis the
Strangers.
tenant. But as far as the landlord is concerned, they have no privity at all.
They are continuing.
They may do that at their risk. But then, as far as the landlord is concerned, he has only one tenant, that is B. C and D may come in for the purpose of doing business there, but then the tenant does not change unless the landlord has agreed that C and D are also his tenants.
So if I receive rent from the B, whether that I want to consent, giving consent to.
You can say that he has become the tenant. There is nothing wrong in it. But then B also should be agreeable for it.
They are disagreeing.
Who B is disagreeing?
Dispute after the partnership, some dispute arose between the parties. So they are in limited times.
But then stricto sensu, it's difficult to say that the agreement between A and B has fallen out. Because agreement is between A and B. Rent has come from D. Unless B agrees that henceforth rent would be given by D as a tenant, and the landlord also agrees that he is accepting D as a tenant, you cannot put an end to the agreement as it is. Because the agreement was between A and B. So unless both parties agree, you cannot bring a third person.
Suppose the tenant is a society, then what will be the implication in this example?
Tenant is a society.
It's a society, like a
People may come and go.
society.
People in the society will come and go.
Yes.
The agreement is between landlord and a society.
Yeah.
Society is a tenant.
Yes.
There is no problem. Just like if the tenant is a company, the directors and they keep changing. There is no problem. Because
In such a case, even if eviction will be there, then what is the problem? Because whether the society will be vacate the premises from the that building.
certainly. Now it's a bank here. You are not given it to an individual, like a person. It's an artificial person, the bank. If you want to evict the bank, you don't say that Ajit Kumar, manager of the bank, manager of Dhanlakshmi Bank. You would put it as Dhanlakshmi Bank represented by Ajit Kumar, who is the tenant. So once you want to evict Dhanlakshmi Bank, you are putting tenant as Dhanlakshmi Bank there. Now whoever is there, maybe there are many officers there, officers who had executed the agreement on behalf of Dhanlakshmi Bank may not be there at all. They might have retired, they might have transferred, but then tenant is Dhanlakshmi Bank. So you can evict Dhanlakshmi Bank from this premises by showing tenant as Dhanlakshmi Bank, provided your agreement was with Dhanlakshmi Bank as the tenant. But if your agreement was with an individual in Dhanlakshmi Bank, then it is not Dhanlakshmi Bank which is the tenant. It is the individual who is the tenant.
In a society, there were no elections at all for a long time. And some claim to be office bearers of the society. And they files a eviction petition.
Who? Society.
Society
Society is the landlord.
Society is the landlord, but they are the persons who file the petition are not duly elected members, duly elected office bearers. Then how it happens? How can it be?
You are basically now saying that the
I am
person
on
who
the part of
represents the
tenant.
society.
I am on the part of the tenant.
Correct. Now the tenant alleges that the society is not properly represented.
Yes.
That is the only issue there.
Yes.
So tenant alleges that the society is not properly represented. That will be adjudicated by the court whether he is properly represented or not. He will be told to produce the document showing how he represents. Because see, take the case, reverse case. Suppose Dhanlakshmi Bank was the landlord here, and they want to evict somebody who is in this room. Even I can just put a petition before the court, rent control court, saying that Dhanlakshmi Bank represented by Vinod Bhatt. The tenant will come and say Vinod Bhatt doesn't have anything to do with Dhanlakshmi Bank. Then court will say he points out that you are not the due representative of Dhanlakshmi Bank. Show your authority. Then I will have to show my authority how I represent. There will be some resolution or something by the society, which is passed by the society or which is passed by the company, to show whether he is the due representative of that particular artificial person.
When there is such a dispute, it will be referred to the civil court.
Not necessarily, because suppose tomorrow it is seen that he has a representative capacity.
And there is dispute regarding
When that is when you have such a big issue. Because as I said, rent control court is simply a court, so it cannot decide on a title issue. But now here, basically, nobody is questioning the title. It is only the representative capacity that is being questioned.
So from that, the minutes of the society should be produced, isn't it?
Generally,
Minutes is not produced, title deed is not produced, they claim they are the owners of the property, scheduled property.
the tenant also will have some deed with him. The tenant
Tenant has
doesn't
already invested
come
the
into possession.
Tenant has already invested a huge amount towards the building
Correct,
of construction of the building. There is no proof at all.
Of what?
For 10 years, he had been fully enjoying the whole building.
As
Nobody was there to claim.
as tenant.
Yes, as tenant. So there is no valid tenancy agreement is also not there.
Valid tenancy agreement is
It's
not
not
there.
there.
So
It's not registered.
is a trespasser. There is no tenancy agreement. Then how is he in possession?
വാടക ചീട്ട് എന്ന് പറയുന്നവരെന്ന് എഴുതുമല്ലോ.
You said there
It
is
is not
nothing.
registered.
ഒന്നും ഇല്ലെന്നാണല്ലോ പറഞ്ഞത്.
അല്ല, it is not registered. Registered ഇല്ല എന്ന് പറഞ്ഞാൽ
Question, it doesn't require a registration. Forget about registration act. If there is something to show that there is a jural relationship, that is enough. There could be, it is quite easy for the courts to find out whether there is a jural relationship or not. Because no landlord or an owner would ever put somebody in possession of a building for about 10 years without getting anything in return. It would be quite foolish for the landlord to wait for 10 years to take an action. So necessarily there would be some paper, and if there is nothing, then still there is remedy for the owner. He would simply say he is a rank trespasser, and he will have to simply file a suit for recovery of possession. If there is no paper at all evidencing a jural relationship.
The contract act, oral contract is a valid contract.
Oral contract of what?
Contract is a valid contract.
Oral contract of what?
Oral contract in the general sense.
Contract of what? End contract? Lease.
Now, whether there can be a case of an oral lease. Without an agreement, what are the essential requirements to be satisfied? Constitute a valid oral lease. Means, suppose lease is to be, I have given my building or whether that is sufficient or something more is required.
Essentially, you don't require a written agreement. For our Building Rent Control Act, you don't require a written agreement. And most of them, you know how they write a lease agreement also, because they are scared of registration. So you keep it under 11 months, then you don't require a registration. And once it is written, it will be there for 11 months, after which basically nobody renews it. And even if you don't have a deed, still there can be a relationship of landlord and a tenant. So essentially,
Whether the handing over of possession.
handing over of possession is essential.
Supposing keys and also.
Symbolic. But it is quite easy to establish. See, once the tenant pays you rent, then relationship is quite easy to establish. Now, there could be instances, the risk that the landlord runs is that, suppose, as he said, there is nothing on record. Key amount elpichu. And from the very first day itself, or he doesn't pay rent at all, then what is there to evidence that it was a lease arrangement? So that rather both parties run the risk of not having an agreement at all. So basically what they do is they write an agreement for 11 months and then that serves the purpose in which there will be a clause that there will be an increment in case you hold over. Or there clause vacue. Now how far all those clauses are acted upon by the courts, that it's a quite a vague area.
Suppose the tenancy is not renewed, what will be the procedure?
It's a holding over.
Holding over. And
The question was, suppose the tenancy is not renewed, then what is the status of a tenant? Tenant continues as a tenant, it's by holding over.
Assuming there is a rent agreement, and in that rent agreement, there is no specific option barring the tenant from subleasing the property. But as a result of that, the tenant is subleasing the property. But the original order was not encompassing the situation. Can he use this act to terminate the agreement?
It is a sublease.
But
Because
that is
kindly
specifically
read 11.4.1.
1141.
11.4.1. It says that it should be written, that the consent should be in writing.
No, sir, but actually the agreement does not specifically bar it.
It does not specifically bar the ordinance unless the agreement specifically gives a right to the tenant to sublease. The tenant cannot sublease. So you are speaking of a situation where it is silent
Yes.
regarding sublease. Silence does not amount to permission to sublease. But then there should be an express agreement to sublease. So unless you have an express agreement with the landlord to sublease, you cannot be subleasing it. That is for the reason that Act has come into force to protect tenants. Now here what happens if there is a sublease? What happens to the original lessee? Who is he once there is a sublease?
Rights against it. Rights
He
against
becomes the landlord then, vis-a-vis the sublessee. So therefore, this Act does not come to safeguard. The intent of the Act was to protect the lessees. So lessees will not be protected if their status gets elevated to that of a landlord. Because by creation of a sublease, what happens? The original lessee gets elevated as a landlord vis-a-vis the sublease.
Even apart from that, he's still paying, the rent is being paid wrong. The only issue is that it has been sublet to another person. But even if still that is the situation, can this be used?
Certainly, payment of rent is even otherwise an incidence of tenancy. So just because you pay the rent doesn't mean that you can do all, you can play all the dirty tricks. I'm saying dirty tricks for the simple reason that it doesn't give you the right to abuse. So,
Two questions. First question is that first question is very simple. Can there be a
let me see whether it's simple.
can there be a landlord tenant relationship without paying rent? In the agreement, there is no stipulation with regard to paying of rent. I'm giving you. Can there be a relationship?
What are the incidents of a lease? I'm putting a cross question to you, counter question. What are the incidents of a lease? Incidents of lease. What do you require for formation of a lease?
Possession has to be handed over.
Possession has to be handed over, and then what is the consideration?
There is no consideration.
Then can it be a lease?
No.
So you said that there is no rent at all.
Yes.
So then can it be a lease at all?
Second question, I look at premises for and for from 2 months I paid, suppose, and thereafter there was an oral agreement in between, apart from the written agreement, there was an oral agreement that he will do some improvements in that, and that was violated by the landlord. So I stopped the payment.
Who was to improve?
The landlord.
Landlord said he would improve the
No,
premises.
no, landlord said that he will make some improvements in the room. That was oral condition, but that was not done. So I stopped the payment. So he came immediately to the room and locked that by restraining me from entering into the room. So I moved police protection.
I think this is a live case for you. You better argue this before the court and argue here. Because my judgment is not going to carry any weight.
So can then police protection be ordered, or the court can direct us to need to
These are all basically something within the realm of a civil code. Because first, the question is whether there was a promise by the landlord to improve, to effect improvements.
we can avoid that question. As far as I'm continuing as a tenant, can the landlord come and lock the room or restrain me from entering the room?
That is a good question. Now you kindly see the powers of accommodation controller. That is, I think it is under section 13. 13. I don't think it goes down to 17. 13 is it? 17. Okay, fine. Whatever it is. Let's see the powers of the accommodation controller. That if there are any amenities which are enjoyed by you, then that amenities at any rate will be protected or should be protected. Now who protects it? It is the accommodation controller. So all that you need to do is approach the accommodation controller and say this landlord is creating all sort of havocs. Like landlords may try to sever the water connection, electricity connection, and such other amenities which are enjoyed by you. Or you may be, having a garage there or a parking area there that may be cordoned off by the landlord. So these are all, causing hurdles for you.
It's a situation where I'm restrained and I'm being threatened by the landlord that if you're entering into the you will be finished. Can I
Outside rent control act agree. Because that is putting an end to the tenancy itself. Because you require two parties. If one party is there, then that's the end of it. That is coming under police protection.
Also tenancy,
Huh?
tenant like a
It will be the other way around.
Residential building, for renting.
Just a second. Somebody's phone is ringing.
Yeah, accommodation controller of each other.
Under the act and it is notified on. Now his orders are also executable. That was
Residential building, for rent for 11 months. And the agreement was executed in the 100 rupees level. Whether that agreement can be produced before the. Is there any informed
question of
agreement executed on the 100 rupees stamp. And as after this dispute has arisen between the landlord and the tenant, can that executed agreement be produced before the court?
well, these are all questions that come under the Registration Act, because once you have, or under the Stamp Act, once you find that there is deficiency of the stamp, then it results in impounding. Now, once you pay the penalty under the Act, then that can be looked into, then that agreement can be looked into by the court. Until then, the courts will not look into it. Though courts would say that even if it is for a collateral purpose, then you can use it, all such things, but general law is that if it is deficient in stamp, then you have to make good the stamp duty, and then alone the courts can act upon it. But I think your question was related to 11-month agreement.
200 rupees in the rent deed.
And for 11 months.
200 rupees in the
Yeah,
rent deed.
for
Reduce
11 for
ചെയ്യാമോന്ന് കോടതി.
for how many months or years?
11 months.
11 months, sir. What is the stamp duty?
200
200. 200 and if there is no change, then 200 is sufficient. Now it is 500. Now it is 500.
200.
Whatever it is, stamp duty keeps changing because whenever the government wants money, they will change it. Whatever is the then stamp duty, if that is seen in the, if it is reflected in the deed, then that is so. That is enough.
One more question. The landlord is a company. The landlord is a company. Is there any special caution be taken? Because if there is a dispute happens, the landlord is a company. They are approaching the court. Any caution to be taken?
A lot of grounds for eviction are lost. Suppose it's a company. Now, how do you bring in 11(8) additional accommodation? There could be difficulties faced for a company to evict a tenant because some provisions for eviction are for the individual. Or there could be difficulty if it's a company. That is all. Otherwise, there is no other problem.
Registered documents, if not registered, it has no evidentiary value at all.
That is 49. So I think
What are the
another 2 or 3 questions.
How can we calculate the fair rent?
Fair rent, see, basically fair rent did come under 5, 6 and 8. Now, 5, excepting 5(1), which gives the power to the court to fix rent, all other provisions have been struck down. And what did the court do? The court in 2004 or 2005, a judgment of High Court, it said how you have to compute the, lay down the directions by which the courts have to fix the fair rent. So they have given the guidelines. It's a judicial, something like a legislation, which the courts are now following. There are about 8 or 10 guidelines that the court has given. But when you can again approach for refixation of already fixed rent by the court. Basically, it is, in the locality, what is the rent? Then you produce a deed which has been executed between 2 willing parties in a nearby area. These are the basic yardsticks. Anyway, they have been enumerated in the judgment itself. It's 2004 Kerala. Just see 2004 or 2005, wherein Isaac 99 has been again, recalled, a part of it. So if you just type Isaac 99 and then see which are the judgments which are followed or referred to, you will get this.
So how it will be evaluated, because even if it is first floor or ground floor, because there are many differences will be there. No?
It is something like how under the Land Acquisition Act, how do you actually come at a value? For the same lines here, the court, does it. It may not be exact, but then it's a guesswork. Just like how it is in the land acquisition, it's a guesswork more, without any exactitude. Any more questions? Otherwise, it's time to thank you.
Thank you very much.
Thanks has come from the other side.
We should thank you.
Yeah, so thank you very much.
Well, that brings us to the culmination of today's session. On behalf of everyone gathered over here, sir, I would like to extend my heartiest and heartfelt thanks to you for not just accepting our invitation, but at the very same time enlightening us with all the intricacies and the nuances of the Building Rent Control Act. That being said about it, thank you so very much, sir, from the very bottom of my heart.